welcome to start.
Thank you. Yes, hello everyone. Welcome to our webinar about the new workplace post-COVID, or should I say perhaps with COVID and hopefully beyond COVID, part 2. My name is Sophie Baas. I'm a Belgian employment lawyer. I'm a partner at the Belgium Ius Laboris firm, Claeys Engels. And I know I will be repeating myself, but I think we can all agree that the pandemic has been the biggest HR experiment ever, because all of a sudden we all had to work from home. And we have seen last year after summer that to some extent, at least, the return to the office was a reality. But unfortunately, the situation is again different, and the Omicron variant forces us all again, at least to some extent in many countries, to work again from home or remotely. But let's stay positive. Let's hope that one day this will all come to an end. But of course, then also another fact is that remote working is definitely here to stay. You hear it from everybody, from family members, from colleagues. We hear it also from client surveys show it that both employees and organizations all around the world, they want to continue to work in 1 or 2 days remotely or from home. And what we see that is based on our experience from the questions we get from our clients is that organizations are looking into this and thinking strategically ahead about the new workplace. And it seems that the new workplace will be a mixture of different models where we will have, on the one hand, employees who will work permanently at the workplace because they do not have a teleworkable function, combined then perhaps with other employees who will be working in more hybrid models where perhaps they will work 1 or 2 days from home and then some other days from the office. And then we have a third category, which is also expanding, or the virtual workers, employees who are just based at home and work from home, be it perhaps in another country, constantly for the employer. So a big mix of new ways of working. And of course, all of this comes with huge challenges, and especially for employers, and even more if we are active globally. And here is actually where we, Ius Laboris, want to come into the pictures, because within Ius Laboris, we have several expert groups. And what we have done, it's a project that had started in September last year. What we have done, we have looked in our expert groups, we have put together several surveys, and those about very hot topics around those new workplace based on the questions we got from our clients. And the result is that we have put together 40 Q&As around that. We have grouped them around 8 topics, and those Q&As have been responded on an average by 35 to 40 jurisdictions. And you can find the result of all those surveys around the 8 topics on our website, on the Ius Laboris website, where we have created a specific web page around the new workplace. And the topics that we have addressed, or where you can find various questions about, are first of all vaccination, and we looked at it from both a privacy perspective but also from a discrimination perspective. We looked also at health and safety obligations for both office workers and remote workers. Working time, what about monitoring working time? What do we need to do if, and does it also apply for remote workers? We also looked at reimbursement of expenses, at how to manage your relations with the labor unions from a distance, so remotely. Also, what about internal investigations if we are in disciplinary procedures and so forth? How do we need to do that? What are the points of attention? Then also we looked at employees who may not necessarily be working in your own jurisdiction, but who would be working in another country where perhaps you don't have a legal presence. What are there the points of attention? And then finally, and that's something completely different, because in the new workplace, we see that there are also other concerns arising, like climate change and supply chain, etc., etc. Well, our pension group also had a look at those challenges and looked at ethical investment applications for pension funds. So if you go to our website, you will find there the specific place. If you click on the topic, then afterwards you will see a series of questions and answers which are based on what we receive from questions from our clients, and the answers covering on an average 35 to 40 jurisdictions. So that is what you can find on our website. But what we are here for today is to learn a bit more about the conclusions based on those surveys. And we had already a first webinar in November where we have addressed several topics, namely the last 5 ones you have seen. But the purpose of today's webinar is to talk about the first 3 topics, namely vaccination, health and safety obligations, and working time. So I'm very happy here to present today our panel, which are actually the heads of our different expert groups. So who do we have here today? So we will first talk with Philip, who you see there. Philip is a partner at our Dutch Ius Laboris firm from the Netherlands, and he is the head of our privacy expert group and will give his conclusions about vaccination topics and questions in relation to privacy. And then we will move towards Yvonne Fredriksson, who is from our Danish law firm, Norrbom Vinding. She was the head of our discrimination group, and she will dive into some conclusions about questions in relation also vaccination. So they both address the topic vaccination, but obviously Yvonne looked at it from a discrimination perspective. Then we will move towards Stefano. Stefano will not talk about vaccination. Stefano is the head of our health and safety group, and he will look at the obligations from a health and safety perspective for both remote workers and office workers. And then finally, Alexander from our German law firm, Klimt, he will look, or he is the head of our individual employment rights group, and he looked at issues in relation to working time, monitoring working time, what is acceptable and what not. So that is in a nutshell what we're going to do today with our panel. I think it's clear that this is just the start, that we still have a lot to discover about this new workplace, but the purpose of today is to give you our conclusions of our surveys from the different jurisdictions, and we hope that this will help you to determine your strategies and your policies moving forward. So, but that is enough for me. I will now would like to know from you, Philip, because you looked at the extremely topical topic, vaccination. You looked at questions in relation to, is it mandatory? Can the employer impose it? What if employees refuse, etc., etc.? So from a privacy perspective, can you share with us some of your conclusions and so forth? You're still on mute.
That's a classic one, and I'm unmuted. Thank you very much, Sophie. And indeed, I'm afraid to say that the COVID pandemic will continue to have an impact for data privacy in the workplace in 2022, as well as in the past years. For almost 2 years now, employers have been confronted with a sort of a balancing act between 2 legal obligations. On the one side, you have the legal obligation and the wish also to create a safe workplace. And on the other hand, you have the privacy rights of employees. So for the past 2 years, we have received questions like, can the employer, and of course, increasingly since there is a vaccine, can employers force an employee to get vaccinated and or tested as a condition to enter the workplace? Also questions like, can the employer dismiss an employee for refusing to do so? But also questions like, can the employer incentivize an employee to get a vaccination, and should they? These and many other questions are, I guess, a big headache for many employers and have been so for the past years. For the sake of this international setting, Sophie, I would like to suggest that we assume that we, the speakers, are now advising a large multinational company. Let's call it XYZ Limited. XYZ Limited has come to us for advice on privacy rights and on a safe workplace in times of Corona. And ideally, XYZ Limited wants to roll out a cross-border policy on COVID-related measures. And let's have a look at what issues that would raise. First of all, in some countries, the government is helping out. In some countries are simply mandating vaccinations, either generally, like for example, Brazil and also Austria, that I'm going to speak about that later on, or more specifically, certain occupational groups have to be vaccinated in order to enter the workplace, like for example, healthcare professionals, border workers, but also staff of schools. Let me highlight a couple of countries because their input was very interesting also to share with this group. In Austria, I mentioned it already, there are, you may have seen that in the news, severe restrictions on the participation on public life to people who are neither vaccinated nor recovered from corona. And also on top of that, the Austrian government announced a general obligation to be vaccinated. So that goes beyond healthcare professionals, and it's going to be introduced next month. In Russia, also interestingly, vaccination is mandatory for a certain group of businesses and also in certain regions. Like for example, in Moscow, there are companies that work in a special field designated by Russian law, where at least 60% of the employees must be COVID vaccinated. And in the US, the Occupational Safety and Health Administration has issued a requirement that employees at businesses with 100 or more employees, they need to be either vaccinated or subject to weekly COVID tests. However, a couple of US states have raised some challenges. They challenged this upcoming requirement, and they did so successfully because last week the Supreme Court in the United States ruled in favor of these states. So at this moment, at least for now, this requirement is put on hold in the United States. In many other countries, the answer to the question whether vaccinations are mandatory is a simple no. And also note that, of course, in countries where there is some form of mandatory vaccination, there is still the overall exception because people simply cannot be forced to receive a medical injection. However, in those countries where you have those strict rules, you would have to have a very good reason for refusing to be vaccinated. If you do not have a valid reason, like a medical contraindication, you are facing potentially employment measures against you, like suspension of payment of salary or even a dismissal. Then there is the question about testing. Can the employer force an employee to get tested? If you look at the outcome of the survey, it was rolled out, like you said, in 40 or so countries, we saw that the outcome of that is more or less 50-50. And in countries where the rules are very strict, like Ireland, Belgium, the Netherlands, forcing an employee to be tested is either not possible or it is only possible under very strict conditions. For example, Belgium, the exception is made in case a high risk is involved. And high risk examples that is mentioned there is, for example, if there is a corona outbreak in the company. But still, even then, only a company doctor can do it, not the employer. So that's a very strict rule. And Ireland also very limited sectors. There is a possibility to do forced testing. And for example, in the healthcare. And even then, the Irish DPA has explicitly said, please be mindful of all the GDPR principles, like proportionate data minimization, etc., etc. And yet other countries are more or less in the middle. They are less strict, but still certain conditions must be met. For example, Germany, since November of last year, there is a temporary federal requirement that only vaccinated, recovered, or tested employees may enter the workplace. So 3G regulation. And as a result, of course, the employer can force non-vaccinated employees to be tested. And on top of that, the federal rules also prescribe that employers must provide employees with self-tests twice a week, regardless of their vaccination status. Similar rules apply in Italy and in Cyprus. And in the Netherlands, a similar temporary rule as in Germany is now proposed for certain sectors, but it's not yet adopted by the Dutch parliament. And that has something to do with the fact that we haven't had a government for almost a year. But that's me being a little bit cynical about the Dutch politics. In France, similar rules apply as in Germany and Italy. There it's called a pass sanitaire, but only to employees who are in contact with the public in certain places listed by law. And in that case, the pass sanitaire is required to enter the workplace. I myself called it a 4G regulation when I wrote the input from France, because the pass sanitaire certifies either a negative test result or full vaccination, or a contraindication to vaccination, or recovery from COVID-19. Important to mention that in France, non-observance of these rules could even lead to criminal sanctions. There's a third group of countries where the rules are even less strict, like Lithuania or Singapore, where regular testing can be required of employees, be it that in Lithuania, it's restricted to a certain group of people. So far, it's fair to say that the legal landscape is rather diverse, and it makes it very difficult for our client XYZ Limited to think of a policy that could be rolled out cross-border. But what about the EU? All EU countries fall under one and the same regulation, the GDPR. And for sure, it's fair to assume that our client XYZ in the countries where they have businesses within the EU, it would be possible to have a cross-border policy. And on top of that, shortly after the corona outbreak, as early as March 2020, the EDPB, the European Data Protection Board, issued a statement saying, and I'm quoting, "Data protection rules do not hinder measures taken to fight the coronavirus. The GDPR allows public health authorities and employers to process personal data in the context of an epidemic." So one should think it's possible to set up guidelines for all EU countries. But unfortunately, it's not quite the case, quite the opposite. Let's compare Belgium and the Netherlands on one side, and then, for example, Italy and the UK on the other side, when it comes to processing personal data, for example, on a person's vaccination status. The Dutch DPA is super strict, still super strict. Everything related to COVID is still regarded as a special category of personal data, and that is a special and highly protected category, and it may not be processed by the employer. Only a company doctor may do it. And by the way, consent is not possible, because consent in the working environment is always deemed to not have been given freely. So we can forget about consent as a legal ground for processing. The Belgian DPA decided in December that at this moment, a hospital may not ask about the vaccination status of job applicants. So a job applicant for a hospital, and the hospital may not ask about the vaccination status. The hospital was forbidden not only to process the vaccination status, but even to ask about it verbally. It was argued by the hospital that just asking the applicant is not a form of processing, and it was also argued that vaccination doesn't constitute health data. Both were rejected, even given the fact that there is upcoming legislation in Belgium, if I'm not mistaken, in April, where there is going to be vaccination obligation for health workers. So that shows how strict the Belgian DPA is. And almost the complete opposite can be said about, for example, Italy. Mid-February, employees older than 50 years of age must be vaccinated to enter the workplace. And then we are talking about 2G. The green pass, that's how they call it in Italy, will be valid only if they are either vaccinated or recovered from COVID. In other words, taking a negative PCR test is not enough. Of course, the younger people below that age, they simply are still allowed. And that, of course, brings some discrimination issues that Yvonne is going to speak about later on. And in the UK, if an employee refuses to comply with a justifiable testing requirement, the employer may have grounds to take disciplinary actions, including dismissal. And again, also be mindful of any discrimination claims, which will be discussed later on. And another view on this whole matter can be found in Denmark, because on the LinkedIn post, the Danish Data Protection Authority stated recently that in their view, information on vaccination status is not regarded as a special category of data under the GDPR. And this is especially for a privacy specialist, a very interesting development, because it would simplify things in a country where the rules are very strict, like Belgium, like my country. And it would be very interesting to see if the EDPB also gives a formal opinion about this. So to summarize, if a global business like our client XYZ Limited wants to roll out a policy, it will have to do so on a country-by-country basis. And in the meantime, we are seeing that companies like LeasePlan, like Shell, it was all in the news quite some time ago. They simply did what they wanted to do. They simply rolled out the obligation for all staff, also in a strict country like the Netherlands, to be vaccinated in order to enter the office. They knew that in many countries it would not hold, but they simply did it anyway. So they simply ignored the rules. And it's going to be, of course, very interesting to see. We are going to closely monitor that. Any legal discussions, court cases, complaints before the DPA in this respect. And I gladly, and of course, there's one thing about incentivizing to be vaccinated, but that also has some discrimination aspects, and that's what Yvonne is going to talk about.
Yeah, thank you, Philip. That was extremely interesting and very challenging for your client in any event. But it is something which we can recognize. Now moving, because you made already the bridge in terms of discrimination. So vaccination has a lot to say about privacy, but also a lot to say about discrimination. And that is, Yvonne, what you have examined with your group.
Yeah, thank you, Sophie. And as Philip already explained, the situation is changing rapidly right now when it comes to vaccination. And one of the major trends also described by Philip is that several countries are implementing or are in the process of implementing mandatory vaccination on a governmental level. And I know that Philip already touched base on this, but I would like to mention a couple of countries again, because they're actually interesting cases for the discrimination perspective or the discrimination discussion as well. And first of all, Austria, which Philip also mentioned, the federal government has just last week presented a draft making vaccination mandatory for all people over the age of 18. And the only exception being pregnant women and those who cannot be vaccinated for medical reasons and people who have recently recovered from COVID-19. Interestingly, also the vaccination requirement will be introduced in 3 phases, implementing sanctions for non-vaccination gradually. And the plan is to carry out checks as part of road traffic controls. And the penalties are expected to, at the end, when we reach phase 3, to range from 600 to 3,600 euros for not complying with the vaccination requirement. And also detention and imprisonment seemed to be possible sanctions. So very interesting development. And from a discrimination perspective, this is, on the face of it, quite easy, because as you can see, in Austria, everybody seems to be treated the same way. And the interesting question then is, of course, could this potentially constitute indirect discrimination if, for instance, a person's reason for not being vaccinated is based on, for instance, religious or philosophical belief, which may be actually a protected criterion in that country. And this will, in my opinion, because it's a governmental decision, this is not for the employer to decide, depend on the constitution and the laws in the country in question. And this was actually recently demonstrated in Brazil, where a number of states and municipal decrees mandated vaccination. And the case was brought before the Brazilian Supreme Court, that decided that, and just to quote, from our Brazilian member, the government cannot force people to be vaccinated, the Supreme Court stated. And this is really an interesting case, and I believe that we will in the future see more cases like with this, where people are going to challenge the government's decisions on mandatory vaccination before the national courts. And in Europe, I believe that we will also see cases on this topic brought before the European Court of Human Rights. I believe that this is something that we're going to see also. Another recent example, as mentioned also by Philip, is Italy, where they have implemented an act requiring all Italian citizens who are at least 50 years old to be vaccinated before the 15th of June this year. And undoubtedly, there are legitimate reasons to mandate vaccination for this age group. But again, people may challenge this decision based on constitutional law in Italy in combination with the European Convention of Human Rights. So again, going to be very interesting to see the legal developments there. Other countries have made vaccination mandatory for certain types of employee, as mentioned also by Philip, for instance, health sector workers, teachers at school and universities. This is the case for several countries, for instance, New Zealand, the UK, Canada, US, and Ukraine, whereas other countries have gone a bit further than that, requiring all employees working on site to be vaccinated. And then, based on the feedback that we have received from our member firms, it seems that there are a few countries where it is in certain situations possible for employers to require employees to be vaccinated. And this, based on the feedback, seems to be at least the case in Denmark, Chile, India, and Hungary. It does, however, also seem that many jurisdictions have a very strict approach to this issue, also, as also described by Philip, where the feedback we're getting is expressly stating that it will not be possible for any employers in any sectors to impose a vaccination requirement unless it has been based on an explicit governmental decision. And some of the countries has already been mentioned by Philip, but again, I could mention as an example, Czech Republic, Finland, Germany, Japan, Luxembourg. And also there seems to be a general agreement in most jurisdictions that it is possible for employers to impose a vaccination requirement on employees. If it is possible, then potentially this could constitute discrimination if the employee's reason for not being vaccinated is based on a protected criterion. And under EU law, this requirement could, in such case, constitute indirect discrimination, and the employer would have to demonstrate then that the requirement is objectively justified by a legitimate aim, and the means of achieving that aim must be appropriate and necessary. Most countries mention that medical reasons would be accepted a legitimate ground for refusing vaccination. Some countries mention that it may constitute discrimination if an employer enforces a requirement for vaccination, if the reason for the employees for not being vaccinated is religion or philosophical belief. But interestingly, actually, one country, Brazil, has specifically mentioned that religion is unlikely to be accepted by the courts as a reasonable justification for refusing a legitimate requirement. And based on the feedback we have received, it seems that there's a lot of focus on the reason being medical reasons. That would be a legitimate ground, but not that many countries mention explicitly other reasons, for instance, religion. So it's going to be interesting to see if we're going to have cases where this is going to be tested, whether religion or philosophical belief would in fact be a legitimate ground to refuse a requirement for vaccination from an employer. Most jurisdictions have replied that it is possible for employers to incentivize their employees to be vaccinated, for instance, by paying a bonus to employees who have decided to be vaccinated. But again, many countries reply that employers should be very aware that it may constitute discrimination if an unvaccinated employee is prevented from participating in an incentive program in a situation where the reason is based on a protected criterion. And again, it's interesting to see that the replies we've received mainly refer to health-related reasons as the relevant protected criterion. So again, it seems that religious or philosophical belief might not generally be considered to be a reasonable ground for refusing vaccination. The UK, US, Denmark, and Poland do, however, as an example, specifically mention religion as a potential protected criteria in this regard. So this was just a quick overview of the potential discrimination cases that we could see out of the situation we're in at the moment. And it's going to be very interesting to see the legal development coming up in the next few months.
Yeah, I fully agree. Thank you very much, Yvonne, for this update and to give your views on this. So moving now to our next topic, which is health and safety. So I'm looking at Stefano, because Stefano, you had a look at health and safety obligations in the hybrid model, so for both office workers and employees working remotely. Perhaps if you can share us a bit of your conclusions and what you have been done.
Absolutely. Thank you, Sophie. Well, I think we can all realize that due to COVID-19, what was the typical workplace has undergone relevant changes, with employees sometimes working from home and other times on site. This new way of working has raised several issues for employers, also with reference to strict related health and safety issues. So we carried on an analysis to check, to further analyze these issues, both concerning the work carried out in the company's premises and remote work carried out remotely. With reference to working activity carried out in the company's premises, we try to understand whether or not local regulations impose on employers the obligation to set up specific safety protocols, providing the measures against COVID-19. The result of this analysis carried out by the Ius Laboris firms clarified that in most countries, Canada, Chile, Italy, just to mention some, it is mandatory for the employer to set up such a protocol. Generally, such protocols include provisions like the obligation to wear masks in common spaces, or specific measures connected to hygiene, etc., instructions for managing positive cases, etc. All these measures in most countries must be included, as I was saying, in a specific document and a specific protocol. On the other side, there are indeed some other countries such as Poland, Russia, Sweden, Thailand, and also Ukraine, in which there's no specific obligation to set up a company safety protocol, but obviously, I mean, needless to say, both employers and employees are strongly encouraged to adopt all the possible relevant safety measures to avoid or reduce the risk of contagion. But the most interesting aspect, I think, in our analysis was the one carried out with reference to remote working, which, I mean, as we all know, is now and will likely be in the next future one of the ways in which a relevant part of the working activity will be carried out by employees. So with reference to remote working, we analyzed whether or not the employer must perform a specific health and safety assessment, and whether or not it has all relevant obligations connected to health and safety on the one side, and on the other side, if employees do have an injury coverage when working remotely or while traveling to or from the chosen workplace. Our analysis confirmed that, as a general principle, so in most of the countries we analyzed, the employer's obligation to ensure health and safety remains in place also when the working activity is carried out remotely. However, considering the fact that, I mean, in such case, obviously the employer does not have a direct access to the actual workplace, which generally is the employee's home. Such obligation in most countries is limited to providing the relevant orientation and training to the employee, informing employees on the risks, which are mainly connected to the computer screen, psychological risks, and this kind of risks connected to the home working. So the obligation is generally limited to providing, as I was saying before, orientation and training and an obligation to inform about the risks. There are also a few countries such as Argentina, Canada, France, and Russia, among others, in which there's no specific obligation to provide such kind of information and orientation. Another interesting aspect that we analyzed is, as I was saying before, the existence of a potential injury coverage in case of accidents while working remotely. And basically, the result of our analysis is that basically in all countries, remote workers are granted some sort of protection against accidents at work, also if for activity carried out outside of the company's premises. There's the relevant exception of Ukraine, in which the relevant law firm confirmed that remote workers' injuries, I'm quoting, remote workers' injuries cannot be qualified as work-related accidents and are not covered by Social Security insurance. So they're not considered at all work-related accidents. And in many cases, although not everywhere, remote workers are also granted some sort of insurance and protection against accidents, also with reference to accident occurred during the normal journey from the place of residence to the one chosen for the performance of the working activity, so both to and from. This protection obviously is recognized with some limits and under some specific conditions which vary from country to country, but we have seen that in many countries there is also this kind of protection. So as we have seen, there are several points, several kinds of regulations which are basically common in most countries. There are obviously, as in every matter, there are some significant differences among countries. We have seen that basically most of the European countries have regulations which are somehow among them similar. Some relevant differences occur with reference to the Americas and Asian countries.
Okay, thank you very much, Stefano, for your overview and your conclusions. I now move towards Alexander for the last topic, which is about monitoring working time, which was already pre-COVID hot topic, but now the question is also rising, what about the remote workers? And also, what about the tools? What is allowed, what is not allowed? Because all of this becomes far more trickier if people are working remotely. So we are very interested to hear about you, Alexander, what your conclusions are in this regard.
Sophie, thanks a lot. And although it's not as fast moving, this topic, as is the case, for example, in the vaccination topic, where we see changes literally each day or at least every week. Indeed, we looked at working time and monitoring working time. And in total, we evaluated the situation in 35 countries. When it comes to the question, are employers entitled to monitor working time? The answer in literally all the countries was that, yes, it is allowed to monitor working time. So employers are entitled to monitor working time. Only in France, also here, the employer is entitled to monitor working time, but it was not recommended, for example, to monitor working time for managing employees in order not to give rise for the argument that in fact we do not deal with a managing employee. So this was more a practical advice in this regard. And of course, in many of the countries, you have to observe co-determination rights within the scope of monitoring working time, co-determination rights of the Works Council or whatever legal representation of the employers exists in the relevant country. If you pose the question slightly differently and do not ask whether the employer is entitled but obliged to monitor working time, the picture changes a bit. In 70% of the countries which we examined, it is also an obligation of the employer to monitor working time, especially the compliance with locally existing working time acts, such is the case in Austria or the Netherlands, just to mention two of them. In Spain, for example, the obligation of the employer in this regard is already expressly regulated in the workers' statute, and the same applies in Poland. So there we have already monitoring regulations directly in the law. And in Brazil, for example, it is an obligation with the exception of high management employees. Nevertheless, in the countries where the answer still was that no obligation exists, especially the European countries, in several countries it is under discussion what's happening. Such is the case in Denmark, for example, or in France, in light of the European Court of Justice decision in the CCOO Deutsche Bank case, how to implement this into the local law. Just two sentences concerning this decision, which goes back to the 14th of May 2019, because this decision of the European Court of Justice has concluded that the member states have to ensure all necessary means to respect the minimum rest periods and to prevent any excess of the weekly maximum working time. And among the necessary measures is an obligation of the employers to implement an objective, reliable, and accessible system to measure the daily working time. And for example, in Germany, you have the situation that there does not exist a general obligation to monitor working time. Only a limited obligation exists, which is that you have to record working time which exceeds 8 hours working time per day. And in light of the decision of the European Court of Justice, we conclude that in Germany, probably we are not compliant implementing the working time directive. And that's why we are also now discussing how to implement this into German law. So also Denmark, France, Germany are discussing this topic. And I think there is more to come in this regard. When you take a look at the question whether the same applies in the employees that work remotely, the situation in many countries is that it does not make a difference whether the employee works on the premises or whether the employee works remotely. Here, in the majority of the countries, the same rules apply whether you work on the premises, remotely, or in whatever kind of hybrid model. However, there are a few exceptions. For example, in Italy, I learned that the answer is that an employer is entitled to monitor working time if the employee is working on the premises, but that this possibility does not exist if the employee is working remotely. In Brazil, there exists an obligation to monitor working time, which does, however, not apply if the employee works remotely. So two countries where which we can highlight here. Then we reviewed the tools that can be used to monitor working time. In most of the countries, a specific form to monitor working time does not exist. And that's why we concentrated our review, our survey on 4 tools just to get a flavor what is possible in the respective countries. And we took camera surveillance, electronic clocks, keystroke monitoring software, and written documentation. And it's probably not a surprise that written documentation can be kept in all of the countries. This is quite clear. However, in Greece, I learned that it's not advisable to use this tool as it must sign by the employee and approved by the supervisor. So there's a lot of administrative stuff in some countries connected with this, but as a general rule, it is possible. And also in the vast majority of the countries, the use of electronic clocks is also okay, and not also okay, it's popular. And it is even still, I want to say, still the predominant tool for monitoring working time. But this, I must say, will probably change in the future if the quote of homework increases even after COVID. Camera surveillance and keystroke monitoring software, on the other hand, is not allowed in the majority of the countries. But for example, in Brazil, based on collective agreement, the use of keystroke monitoring software is possible, but camera surveillance not. In Saudi Arabia, for example, also keystroke monitoring software is possible. But as said, in most of the countries, it is not allowed as this type, the keystroke monitoring software is not allowed as this type of software enables the employer to constantly monitor the professional activity of the employee. And not to forget that in many countries, even the implementation of monitoring via electronic clocks can only be implemented with the consent of the employee's representation existing in the company, or is the case in other countries where the trade unions are represented, then the consent of the trade unions must be obtained. The Works Council or other representations, such is the case in Germany or in Finland, for example. Concluding, one could say that the more the tool to monitor working time can have an impact on the dignity of the employee, the more restrictive its use is. And in other words, monitoring via especially keystroke monitoring software can only be implemented if it is reasonable and proportionate. And reasonable and proportionate is not the case with keystroke monitoring software. Having said this, generally speaking, techniques such as keystroke monitoring software, camera surveillance would in many countries not be a recommended way of monitoring working time. And finally, we reviewed what are the global trends in this respect. What I can see so far from the answers provided is that monitoring working time indeed is a topic which is intensely discussed. In France, for example, where remote work is implemented by a collective bargaining agreement, the collective bargaining agreement must also set the time periods during which the employer can usually contact the employees. So the protection of the employees in the new working model is still to be defined, and I personally expect more restrictions to come to protect the private life within the scope of remote work or hybrid work. We see models at the beginning based on self-registration of the employee, of his work time and rest times, but it is, I think, when you look at the situation in France, where you have to speak to the employee on a regular basis and set your times during which you can contact the employee, the right to disconnect is something which will be intensely discussed still within the scope of the hybrid models or the remote work. This was basically the outcome of the questions that we posed to our member firms, Sophie. Sophie, you unmute still.
Sorry, again, my fault. It's a classical one. So thank you for what I wanted to say is thank you very much, Alexander, for this interesting overview. And I agree that the right to disconnect will without doubt be one of the most most important topics that we will need to follow in the future to see what the legal developments will be. But perhaps also another question to the panelists, a bit building further to what Alexander, what you have highlighted here, as we are all employment lawyers, what do you think in this new workplace will be the most important challenges for employers, and perhaps also besides the right to disconnect, do you see any other areas where we will see legal developments where employers, and in particular global employers with a global workforce, have to be prepared for? I don't know whether there is any volunteer to say something.
Yeah, well, perhaps I could say something about monitoring working hours with monitoring software that register the number of keystrokes on a computer. Of course, me as an employment lawyer with a focus on data privacy, I have to comment on that because that is something that also from a data privacy perspective, like Alexander said, would be totally in breach of privacy laws in many countries, not only the GDPR. Also because monitoring working hours is then often mixed up with monitoring performance of the employee, and it's very doubtful whether monitoring software could ever monitor the quality of the work of an employee. So there are so many cons against those types of monitoring software, and that means that there's still an issue of how to monitor working hours without it becoming a form of monitoring of performance, and that's is going to be a challenge for many companies.
Yeah, indeed, Philip, and I totally agree. And the same, applies to camera surveillance. Usually, I mean, there are probably other tools which have a lower impact on the employee, and you could use monitoring software. Maybe if there is a strong suspicion against an employee, that would be possible to use it still, not as a general rule to monitor working time, but when there is a suspicion that the employee has done something wrong, committed fraud on working time or so, that you could use these tools. Still, this is possible, but as a general rule, not. But what I, in addition, also expect is, we are discussing in Germany right now what happens after COVID with the home office. Yeah? And our Ministry of Labor already announced that he is starting a new initiative, another initiative, to implement the right of the employee to work from home. And this is something I think which still need to be shaped in the future further. I mean, right now everyone can sit at home and can work at home, but this is just for the period of the pandemic, and still no real legal basis exists in this regard. But this is probably to come. There was in the last governmental situation or a first attempt to do this, which did not become law. But now with the changed government in Germany after the election, it's very, very likely that, for example, a new regulation concerning home office, which gives the employee a right to work from home, will enter into force.
Yeah, and that is copy paste the same in the Netherlands. There also is already a legislative proposal for a legal right to work from home, and now it's only a legal right to ask for it, and then there is the duty to consider, but only that. And it's very possible that in the Netherlands we will get that legislation.
Yes, Yvonne, any other developments?
Yeah, just a quick comment on that, actually, the remote working, because, and this is on the face of it less legal, but what I see that many big companies struggle with at the moment is really to find the right balance, that they would like to allow home working, but also they are actually being pushed from employees to be allowed to go to the office. So finding the right balance, where some companies tend now to have people do more and more work from home. And actually there are employees that prefers to go to the office to work. And the other way around, that I see companies that are in a situation where going out and trying to recruit new employees, and the employees ask, how much can I work from home? So it's really also a matter of how do you attract talent at the moment. It seems to me that this is something where the companies are at the moment struggling a bit to find the right balance to attract and retain talent. So this is less legal, but then when you take it from there, of course, the challenge will be to prepare a contract that make sure that you have the legal situation described in the right way to protect both the employer and the employee in regard to the agreement that's being made on this. So I see that as something that is going to be, there's going to be a lot of focus on also in the future.
Yes, and I fully agree. I see that we have 4 minutes left, and I would perhaps want to ask one question we received, which I found quite interesting. It's for you, Stefano, because you have said that there is an injury coverage for remote workers in generally speaking. But the question is, what happens if the employee is working from a foreign country? Is that coverage then also applying, or is what do you have any thoughts about that, or what does Italian law foresees in this respect? So,
well, it is not a very easy question. It's quite something which is a bit debated in Italy. My answer would be if the employee, by its own decision, without any kind of communication either to the employer nor to the relevant insurance body, decides to work abroad, then likely there would be no coverage in this case. It could be different in case in which it's something agreed, or if it's the employer asking the employee to work from abroad for some reason. Generally speaking, what we recommend in these cases is to set up specific private insurances to cover this kind of risks. Sorry, if I may just to jump on what we were discussing
okay.
before on the other topic. Alex was mentioning about the issues related to the right to disconnection, etc. He was obviously analyzing this from his standpoint, which is connected to the monitoring of working time, etc. But obviously, this also raises some issues from a health and safety perspective, because obviously, in this new working organization in which several employees work part of the week, or some of them the entire week from home, then the distinction between working time, rest, etc. tends to be not so evident, not so clear. And this may determine the fact that employees are permanently connected, which also determines, obviously, apart from the monitoring of working time problems, also it might raise some mental issues connected to the excessive stress, etc. And from another standpoint, there's also there could be problems if this kind of model keeps on going in this kind of way in the future. Also problems connected to employees working permanently isolated from home. So also this could have some sort of psychological influence and could raise some issues from a strictly health and safety perspective, in my opinion.
Yes, thank you very much. I'm also looking at the clock. I see that it is exactly time, so very well done to stay within the time. I'm just looking whether there are any other questions, but I think we will need to stop here. So first of all, I want to thank the panel for your very interesting views. I also want to remind everybody that you find the detailed reports and surveys and all the questions. There are 40 in total around those 8 topics that you can find it. So responded on an average by 35 to 40 countries, that you can find it on our Ius Laboris website on the dedicated page about the new workplace. So then the only thing I can do is thank you very much for your attendance. I hope you found it very interesting, and I wish you a very pleasant further afternoon. Bye-bye.